It's great to be here again with everyone, and hopefully a lot of you have had the chance to work with our office before, or at least to have heard of us. And in summary, what we do is we help resolve disputes in the eminent domain and the land use arena, as well as provide education and training to private property owners in the eminent domain area and land use area, as well as local governments. So we have that those purposes. And so, certainly being able to come and talk to everyone about conditional uses today is right up our alley and something where we appreciate the chance to do. So I want to make sure that this is as helpful to people as possible. And so, there's certainly going to be time at the end of this to have some question and answers. And if, though, during the presentation something comes up that you feel is unclear or you have some other question come to mind, feel free to jump in with a question. I'm happy to take questions anytime. And again, the goal here is to be as helpful to you as possible. So with that, we'll jump right in.
All right, and just once again, Jim, if people have a question, they can type it in the chat box or the Q&A box that they can bring up, and I will try to feed those to Jim as we go along. And so if you have those questions, please get those in. These tend to be presentations that have a lot of questions, so think about those and get them in early so we can make sure to fit them in. Okay, great. Yeah, thank you. So here's just a brief roadmap of where we're going today. Conditional uses, it's a part of zoning. So I'm going to just give a brief zoning law overview, just so we can sort of situate where conditional uses fit in the broader picture. Next, we'll go ahead and take a look at some conditional use basics, things to consider and things to know in terms of state law and other considerations as you're looking at conditional use applications and how to handle those. And then finally, we'll go over a couple of case studies to apply some of the things we talk about. The first case study will be a situation where a conditional use decision of a local government was overturned. And then the second case study will be where it was upheld. We can take a look at those and see what went differently. So, okay. So zoning. When we're talking about zoning is the regulation of land uses and structures in a specific geographic area, and it's within a jurisdiction. So zoning ends up restricting to some extent private property rights, and this is not something that just always was. Towards the beginning of the last century, this was a new concept. And a very important Supreme Court case came out, Village of Euclid v. Ambler Realty Company, where the U.S. Supreme Court established that zoning as a general principle, zoning as a general principle is a constitutional endeavor by local governments. And what happened in that case is the Village of Euclid, which is a suburb of Cleveland, instituted some zoning ordinances because they were afraid that the industrial uses of Cleveland were expanding and were going to overwhelm their little village. And they wanted to prevent that from happening. So they put in these restrictions that would prevent industrial uses, and it applied to Ambler Realty Company's property, among others. And this landowner wanted to build these industrial facilities on the property, and they sued because they felt like it was unconstitutional. And the Supreme Court, when they analyzed this, they ended up upholding the law, the zoning law, and said that no, this was a legitimate use of the police power of the local government as long as there was a rational basis for the law. In this case, they found there was a rational basis. And so as a general matter, zoning is constitutional in the United States. And, it wasn't until many decades later that a lot of jurisdictions ended up instituting zoning ordinances, some as late as the 60s and 70s and even after. So that's sort of the 50,000-foot view of this, the U.S. constitutional view. At the state level, what we have here is the Land Use Development and Management Act, or LUDMA. And there is an act that applies to municipalities found at 10.9a 101 and the following sections, and then to counties at 17.27a 101 and following. And as a side note here, I'll be citing to the municipal LUDMA just for simplicity's sake, so we don't have to have more citations than are necessary, but know that the statutory provisions that we end up talking about are going to have the identical provisions in the county LUDMA as well. They may be off by a section, just depending on the specific provision, but they're there. So, with LUDMA, it gives local jurisdictions broad authority to pass laws to promote the purposes of LUDMA, which generally are to promote the general welfare. Going further, LUDMA gives the express authority to enact zoning ordinances. And so we know that it's been deemed constitutional at the federal level. At the state level, there's this general idea that you can pass laws that promote the general welfare, and more specifically, state law gives jurisdictions the right to pass zoning ordinances. Now, we're talking about conditional uses, and there's a provision in LUDMA that a land use ordinance may include conditional uses. So there's a specific provision in law allowing for the inclusion of conditional uses in your zoning ordinances. Okay. So, as we're talking about conditional use basics, let's take a look at this. And I apologize here, as we're going to see a few slides that have a lot of text. I know I'm violating PowerPoint protocol, but I felt like it was helpful to have the actual language of the statute at times up here, and so we can go through it and not have to refer to something that's not right in front of us. So in LUDMA itself, it defines conditional uses. Conditional uses defined as means a land use that, because of its unique characteristics or potential impact on the municipality, surrounding neighbors, or adjacent land uses, may not be compatible in some areas, or may be compatible only if certain conditions are required that mitigate or eliminate the detrimental impacts. And so, as a general rule, it's important to keep in mind that if there are conditional uses, the legislative body of the jurisdiction has decided that as a general matter, we want these conditional uses in this zone, but because of certain impacts they may have, for example, if they're located in this particular zone too close to a high-density residential or some other use, we may need to mitigate some of the detrimental impacts that may occur that would not be of a more general concern to the permitted uses generally in the zone. And so, as we're talking about conditional uses, it's also important to remember that the inclusion of conditional uses is optional. You do not have to have conditional uses in your zoning ordinances. So here's the statute here that says that expressly. A land use ordinance may include conditional uses that require compliance with standards set forth in an applicable ordinance. And so the first part of that talks about the fact that they are optional. The second half of that ordinance talks about, or that statute talks about, that there should be standards set forth in an applicable ordinance to give guidance as to whether or not certain standards are being complied with. And these standards should be found in this applicable ordinance. And we will talk about this, and I'll give you an example here in just a minute about what one of those ordinances may look like. But it's important to keep that in mind, that the conditions that we're talking about that may be imposed just aren't pulled from the air. There needs to be some kind of standard in the ordinance that gives guidance on those things. And again, we'll talk about this a little more in a second. One of the most important things to remember as well about conditional uses is the fact that it is an administrative action. And so the legislative action has already happened, meaning that the council has already decided as a legislative policy matter that this conditional use, if there are conditional uses, are a desired use in the area, subject to being able to mitigate the potential detrimental effects. And so we're gonna talk more about what this means again in just a second, but I want to raise that right up front, that it's important to keep in mind that it's an administrative action. So this next bullet
is another state statute that gives really, really important guidance, mandatory guidance, on how you go about evaluating a conditional use application. And it says here that you must approve it if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. And so again, we can start right here. It talks about the applicable standards, and those are the standards that we referenced earlier that are found in the ordinance. If I go back here, bullet point 2 there, the conditional uses will require compliance with standards set forth in an applicable ordinance. And I'll give you an example of that here in just one second. But that's what those applicable standards there are referencing. It's important to keep that in mind. So when you are evaluating an application for conditional use, and I'll put in a side note here that state law does not say who exactly it has to be, whether it's staff or a planning commission decision. That's up to the discretion of the jurisdiction to pass ordinances on that. But regardless of who it is, when you're evaluating an application based on this mandatory provision of state law, you need to identify the detrimental effects that are reasonably anticipated for the conditional use. And you need to do that because you need to know what reasonable conditions might then mitigate these detrimental effects. And you have to make sure that all of this relates to the standards in the ordinance. And so, and the reason why this has to happen is because, as is stated there in the first bullet point under applicable state law, if reasonable conditions are proposed or can be imposed, and they mitigate these detrimental effects in accordance with these standards, then you have to approve it. The discretion, just the general legislative discretion has already been made. And so let's take a look. So I've mentioned this a few times now, this idea of applicable standards. So I'm going to show you an example here from South Salt Lake. This is, we're not trying to say that this is the only way to do it, or this is how everybody should do it. We're just saying that this appears to us to be a nice example of how they have set forth standards in their ordinance to guide them as they make these conditional use application determinations. So it's going to be a lot of text, just fair warning. So here's a part of that ordinance, and maybe we can go through some of this. And again, at the beginning there, the land use authority is going to require each conditional use applicant to address the following standards where it's covered up. I think it says where appropriate. So let's take a look, for example, at B1. So let's read B actually to begin with. So use compatibility. Reasonable conditions may be imposed to ensure optimal compatibility with the character of the site, adjacent properties, and existing development within the vicinity of the proposed site. In determining compatibility, the land use authority considers, 1, whether access to the site can be achieved without materially degrading the service level on any streets which would serve for access. So you could then take a look and get evidence on whether or not this use is going to be, what kind of trip count it's going to engender, and whether or not with this trip count it's going to end up degrading the service level. You can take a look at, for example, in 4, whether buffering or other mitigation measures will be provided to protect adjacent lands from unlawful or excessive noise, light, odor, or visual impact, or from other unusual disturbances from deliveries, mechanical equipment, or trash collection. And so, for example, say you've got a conditional use, a commercial use that's adjacent to a residential area, and they may be having a lot of light based on this use. There may be conditions that need to be imposed after looking at the evidence and the hours of the light and how much light will be emitted, that maybe there needs to be dimmers, some sort of light screening, or maybe the lights need to be simply turned off during certain hours to avoid that sort of light pollution in the adjacent residential areas. For example, if there's maybe a dog kennel There can be evidence taken on the number of dogs, the amount of waste that will produce, and then conditions relating to the frequency of the cleaning requirements for the dog kennel in order to protect residents and surrounding property owners from odors. It's those sort of things that that will be considered as you take evidence that is based on these standards found in the ordinance. And so, it's important to note here that it's not just sort of walking in with a clean slate and deciding whatever comes to mind in terms of how you want to approach this. There should be direction from the ordinance itself. And again, it can be, like in 4, excessive noise, light, odor, visual impact. That's not exactly measurable. So these don't have to be, exactly measurable. They can be a little general. But again, at least you're given guidance here in the ordinance as to what it is you're going to actually be looking at. And so, hopefully that's just, it's just one example of something that our office appears to work. And so, again, if many of you probably already have these and it's not an issue, but if you're looking around and thinking about maybe beefing this up in your ordinances, this is one place to get some ideas from, and there's certainly plenty of others. So I just thought it would be helpful to take a look at this as we're going through the process for actually evaluating your conditional use applications. Okay, this is, I'll give you a slide with mainly just a picture to try to balance things out a little bit here, but this is a really, really important point. You must remember it's an administrative decision, and over again we see problems when jurisdictions forget that it's administrative in nature and not legislative. People try to take this as a legislative matter where whoever's evaluating the conditional use application ends up using legislative discretion as to whether or not they want to grant the application, if they want to permit it. And, they also forget that even if they are going through the ordinance, that for an administrative decision, it requires a higher level of evidence than a legislative decision. The legislative decision's already been made. Once there is a conditional use on the books in a particular zone, the legislative bodies decided as a matter of policy in their discretion that that's what the jurisdiction wants. And so, you're in a different framework once that's been done. Let's just take a quick review here of legislative decisions and administrative decisions. So legislative decisions basically make law, and it's done by the legislative arm of the jurisdiction. Administrative decisions apply law that has already been made, and it's applied to particular properties. It's not general in nature. The standard of review as well for these to be upheld is also different. There's more discretion at the legislative level. There's not as much discretion at the administrative decisions. There has to be substantial evidence on the record. And for appeals, you need to exhaust your administrative remedies. We'll talk here about appeals. So this first bullet point is another state statute that gives guidance on what to do and what your options are with conditional use applications. So we went through earlier about when you must approve the application. This slide will tell you when you may deny it. And it's pretty clear that if the reasonably anticipated detrimental effects of the proposed conditional use cannot be substantially mitigated by the proposal or the imposition of reasonable conditions to achieve compliance with applicable standards, then you may deny. And so, again, it's important to note there that you're looking at this with the backdrop of achieving compliance with the applicable standards that are found in the ordinance. And the statute does not require you to impose any conditions to achieve compliance. There is that qualifier of reasonable conditions. So if reasonable conditions really aren't available, if you would need to shrink down the footprint of the building to 20 square feet in order to make it work, I mean, at some point you say that's just not reasonable. We can't make this work with reasonable conditions, so we may deny it. So you've gone through this application process. You've taken a look at the application. You're keeping in mind it's an administrative matter. You're here to apply law that has already been made, and that you need substantial evidence on the record. You go through and say, what are the detrimental impacts? What are the conditions that we can impose? And having all of this be in compliance with the applicable standards in an ordinance. Okay? So you've done all that. You've got the evidence that you want. You feel like, okay, we've got substantial evidence in the record, which, by the way, is evidence, and it's on the last little point here. It's evidence that's sufficient to convince a reasonable mind of a conclusion. It doesn't have to be the best evidence on a matter, but it has to be more than simply public clamor. Negative comments from neighbors, public clamor, that is not evidence. And so even if you have statements on the record of this kind of thing, your decision will not have been supported by evidence on the record. So, okay, so you go through and you end up making your decision, and as is not uncommon in land use decisions, you have people who are upset. We're not happy with the decision. So what happens then? I want to kind of go through the appeals process and how it works and the standards that apply to appeals. And so first of all, as mentioned just briefly earlier, given that this is an administrative matter, you have to exhaust your administrative appeals process. And so there'll be some kind of appeal authority there at your jurisdiction that would hear this. Following your ordinances in place. And then once there is a final decision after it's been determined by the appeal authority, then any aggrieved party would need to file an action in district court within 30 days of that decision becoming final. Again, I've given you throughout here the cites to the state code so that you have that for reference as to where this law is coming from. And then in LUDMA as well, we are given the specific standards that are used for determining when a court will uphold a decision, a land use decision. And this has come from other case law that they have been codified into state law. And so, courts aren't looking to be able to overturn land use decisions. They're going to assume that it's legal. However, they will review it and they'll uphold it as long as it is not arbitrary, capricious, or illegal. So now we need to sort of get down in here a little more and figure out, well, what does that mean? So it is illegal if it violates a law, statute, or ordinance in effect at the time of the decision. So for example, if you end up issuing an advisory opinion, I've gone to the Property Rights Ombudsman's office, what we issue. But if you end up permitting a conditional use and it's for a use that is not one of the listed uses in your ordinances, then there's a pretty good argument that what you've done is just illegal because it didn't follow your ordinances. Now, the arbitrary and capricious, that is determined if there is not substantial evidence in the record to support the decision. So no substantial evidence in the record, which again means evidence sufficient to convince a reasonable mind of a conclusion. If you don't have that in the record, then it's arbitrary and capricious. And therefore, if appealed, you run the risk of that being overturned. And so, it's important to keep in mind as you're going through this whole process that you want to have a record developing of why you are making a decision. There needs to be evidence in this record that consists of things other than public clamor or negative comments. So for example, what can that be? There can be testimony, but it's helpful if it's testimony from expert witnesses, folks who know what they're talking about. For example, if it's an issue of property values, it can't just be neighbors coming up and saying, this is going to devalue my home. If you have an appraiser, or at least a broker that, you know, has some sort of experience and expertise in this that will come and say, you know what, this is my opinion and this is why, and can submit some items, you know, and talk like that. That is certainly going to carry a lot more weight and can be, you know, likely deemed as substantial evidence in the record, as opposed to, you know, a neighbor simply saying, you know, we don't like this. And so, you know, so again, just keep this in mind as you're developing the record, because once it's gone to appeal in the court, you're not going to be able to put witnesses on the stand and develop that record, you know, at that point. The court's going to look at what's been already done. So,
Jim, can I ask a question?
Please, absolutely.
So when you're doing this and you're developing this evidence, obviously we want to document this in minutes from our meetings.
Mm-hmm.
Is there kind of a fine line between putting too much and not enough?
Sure. Yeah, and I'd say as you're looking at this, think about sort of on a sliding scale. The way I would analyze this is, how controversial is this decision? Okay, so if it's a decision that people really don't seem to care about, it's just more of a perfunctory sort of, you know, not a lot of people are getting excited about it, and you're just not seeing it as being very controversial, you probably don't need to have a whole lot of evidence on the record. You don't need to go through and look for, you know, evidence and studies from, you know, Harvard or whatever to support your decision. Okay, just having just very basic stuff would be great. You know, on the other end, and I'll go over this here in one of our examples that relates to a shooting range, you know, is very controversial. At that point, you're probably going to want to have more evidence on the record, because you're getting evidence on the record from the other side. It's more than just neighbors showing up saying we don't like this. And so, you know, you need to balance this while thinking about, do I have enough evidence on the record to convince a reasonable mind of a conclusion? And again, if it's an uncontroversial proposition, you probably don't need very much evidence to convince a reasonable mind of a conclusion. If it is something where there is a lot of contention, then maybe you need some more. And so I would say the way to sort of balance that is looking at how controversial is the decision and how much opposition are you getting from it in terms of actual evidence on the other side.
So you would tend to lean towards adding multiple reasons, multiple evidences, versus just hanging your hat on this is one thing that we disagree with, really, so you can make it stick.
Well, I guess it would depend on, you know, I don't know that you need a whole lot of evidence if it's a pretty simple, straightforward conditional use permit that you're dealing with.
Okay.
Because
Great.
if no one has shown up and disputed it, then evidence is going to be sufficient to convince a reasonable mind to support your conclusion that, yeah, we should allow this. Not going to be very much. You know.
Great. While I've interrupted you.
Oh yeah.
Go ahead, Jim. Sorry.
Go ahead.
We had one other question here. Blaine asked, how do private CC NRS play into this process, if at all?
Mm-hmm. Well, my take on private CC NRS, you know, that is a private contractual matter amongst people who choose to buy into a development, for example, you know, a PUD, where there are these CC NRS that are encumbering their property. You know, that is not something that is, I mean, it's sort of like private zoning, I guess, but at the end of the day, you know, I'm uncomfortable with the idea that municipalities would be sort of leaving their traditional role of determining the public good and following their own ordinances to try to interpret and enforce private contracts, you know. And so if someone comes and, you know, ends up presenting an application, and I assume this question is related to, well, what happens if someone comes and, you know, applies for conditional use and it violates their CC NRS? You know, my take, sort of the bottom line is, you know, then if they decide to go through with it, they might get sued. You know, and that may be one of the things that you look at as you're going through this application process, because presumably the reason why that's not wanted is because there will be detrimental effects. But just kind of my take on this is, and there's no law, in state code, state statutes here in WUDMA that's going to give you the answer on this. And I'm not aware of any case, although maybe someone out there is, and if you are, please let me know. But this is more of a practical determination that the city does the city's things. The city deals with their own ordinances, or your land use jurisdiction if you're a county. And then matters of CC NRS, that's a private matter. And if people choose to go through and get permitted for something that is legal under the under the laws of the jurisdiction, and they choose to go through with it, they might get sued. But again, given that they may involve detrimental effects, and that's the reason why they are, for example, violated in the CC NRS, that may give you something to look at in terms of as you're going through this analysis. And if you have any follow-up on that, I'm happy to take it. So.
No, that sounds great. Thanks, Jim. I appreciate it.
Yeah.
Yeah, and Blaine responded back that was his understanding. So
okay.
He was thanks you for that.
Yeah. Well, happy to. Yeah. Yep. Okay.
Okay, throw it back to you.
Any other questions? Okay, I say, hey, if there's more
well,
questions.
I do actually have one other question. I was trying to decide if we'd held that one to the end. The question is, what if you grant a conditional use permit and then in the future they end up not complying with the conditions?
Well, that's certainly one of the conditions of, and one of the preconditions for being able to continue a conditional use is compliance with the conditions. And so, a lot of jurisdictions will have in their ordinance that compliance with the conditions that have been imposed is a condition of continuing on with the conditional use. So I would recommend having that in the ordinance so it's very clear. I think that there's a reasonable argument that even if it's not in your ordinance, you could fight this, but I think you can have a much easier time if it's just simply clearly articulated in your ordinance that compliance with the conditions are a requirement to continue on with the conditional use. And so if there is non-compliance, then you're being issued a conditional use does not give you a perpetual property right if there are violations of the conditions, because you will not have met all the steps that are required to get the conditional use at that later time. So it's something that is can be reviewed and potentially revoked if the conditions are not complied with. But to clarify again, I would say you're better off having that provision in your ordinances so it's straightforward and clear to everyone.
Great, thanks.
So, Yep. Again, if there's more questions, bring them. And I'll start with the case studies. And again, we're happy to take some questions here at the end as well. So one of the more famous Utah cases on conditional uses is Wadsworth v. West Jordan. And in this matter, Wadsworth wanted to build an office as well as a warehouse on some property it owned, and then to have some outdoor storage to go along with this to store some of their construction equipment. And this was next to some property owned and operated by Dannon. And West Jordan had expended a lot of effort to get Dannon to locate in its city. And when the application for the conditional use came up, and it was, the planning commission, and they were receiving public testimony, a Dannon employee came forth and said, "Hey, we're not real excited about this because outdoor storage tends to attract rodents," and voiced their displeasure. And there were other property owners and neighbors that came up and said, we really don't like this because of the noise and the dust and these different issues. So the planning commission said, yeah, those aren't great things. We're going to go ahead and deny this application. Wadsworth appealed it through the administrative appeals process. City council heard it. They said, we're going to make these findings. We have found that the city of West Jordan has expended a lot of effort and resources to get Dannon to locate here, and that if we were to allow this conditional use, it would be injurious to the goals and standards of the city. And so we're going to go ahead and deny this. And they had, again, people coming forth and saying that we don't want this, and rodents and dust, etc.
Well, Wadsworth appealed this, and it ended up at the Utah Appeals Court. And the court analyzed this and said, well, it's an administrative decision. So was it arbitrary, capricious, or illegal? And they looked to find out if it was arbitrary or capricious. And in doing that, they asked themselves the questions, well, was it supported by substantial evidence in the record? And in looking at this, they said the record consists of findings by the city council based on public clamor. And at the planning commission level, it was the same public clamor. That's all that's in the record. And the court ended up overturning the denial. And so it said, no, this is not sufficient to base your decision on. So that's it's an important case to keep in mind as you are going through and creating your records for conditional uses, because courts will overturn matters that are decided, and if people are upset enough about them to bother to go to court, if they are not supported by substantial evidence in the record. And so there's an example of when a court overturned the decision to deny the conditional use. Now, in this next one, I referenced here, there was a conditional use applicant that came in wanting to build a gun range. And this was an advisory opinion that came to our office. So just for clarity, we aren't judges, and so this has no precedential value. This is not like a court case, but this is our attempt to take a look at a fact pattern and decide it in the way we think a court would decide it. And so we took a look at this, and in this particular case, the jurisdiction upheld. Or they didn't uphold. They granted the conditional use to have this gun range. And the city, when they ended up getting the application, they took a look at it. They looked at the detrimental effects, they identified them, and they had hearings, multiple hearings on this. They looked at the conditions they could impose and made sure that this was all being bounced off their ordinances to make sure it was in compliance with the standards set forth in their ordinances. And they did this, and through this process, this was close to a residential area, and a lot of the neighbors came up, and they were very well organized. They didn't just show up and say, we don't want this. They came and said, according to these academic studies, these are the harms that happen with gun ranges, and these are the things we're concerned about. There are concerns, and there are also concerns and conditions imposed relating to noise, security, emissions, things of that nature. And so they went back and forth, and the city built this record of evidence, including expert testimony. There were studies that were done. There were engineering plans, in favor of the gun range. There was also expert testimony, studies done by those who were opposed to the gun range. And so ultimately the city said, you know what, based on all this evidence that we've heard, we feel like at the end of the day, we have conditions here that are reasonable that we can impose that will mitigate the reasonably anticipated detrimental effects of this use. Therefore, in accordance with the standards in our ordinance. And therefore, the city said, we have to approve this. And they did. And the neighbors came to our office and asked for an advisory opinion. And we took a look at this, and again, applying the standard that a court would apply, we looked through the record and concurred that the decision was supported by substantial evidence, or in other words, evidence that was sufficient to convince a reasonable mind to support the decision, and decided that it was not illegal, and that therefore, even though the other side had substantial evidence as well, courts aren't going to weigh the issue anew. They aren't going to decide right from the beginning which side has the best evidence. That's not their role. That's not what they do. They're going to say, was the decision supported by substantial evidence? If so, even if maybe the other side could be argued to have had better evidence, as long as the decision was supported by substantial evidence, then we're going to uphold it, as long as it was not illegal. And so that's what our opinion did in this case, where we said it was not illegal, it was supported by substantial evidence in the record, and we have no grounds to think a court would overturn this. So there's a couple case studies on this, and again,
right now I'm happy to take questions here, any questions you have. But I know that there's going to be questions that come up with this down the road, or maybe you'll think of something later, or something you just want to talk about offline. But here's our contact information. There are 3 attorneys in our office. Any one of us would be happy to speak with you about this. And you know, don't be shy about giving us a call. So.
All right. I'm just if people want to ask a question, please go ahead and type those into the chat box or the Q&A box, and we'll get those to Jim to answer. Well, Jim, that's been a great presentation. It's helped me understand a little better what our standing is, and really I feel much more comfortable in the protections that we have from the court, as long as we really do our due diligence to have some substantial evidence there. Waiting for some questions. You must have done such a great job that we don't have a ton of questions, which really surprises me.
I did a great job, or what?
No. That was not what surprised me. I might have said that wrong. No, that was an excellent presentation. Normally these subjects definitely have a lot of questions directed after the fact, but I think you've done an excellent job and made it very clear. So really not seeing a lot of questions coming in.
I hope that I didn't confuse people. Again, if there are questions that come up later, please don't hesitate again to give us a call. We, I think sometimes people are hesitant to do that from the government side, but we, in the statute, our role is to try to help give information about what the law is and how people can comply with the law to jurisdictions, as well as to, helping private property owners protect their private property rights. So, don't hesitate to call us. We're here as a resource, and we'd like to make sure that help people do things the right way and stay out of trouble. So.
Great, Jim. Thank you so much. Hey, just one question. I had some folks ask if we could distribute those slides, just a PDF of your slides. So we will email that out to everyone who signed up for the webinar, as well as we're recording the session, and we will place that on our website either this afternoon or tomorrow, and we'll send out an email to let you know when that's up. I know there are quite a few planning commissions out there that were looking to use this as some training in an upcoming meeting. So just refer back to that and look for that email to come out. And as far as questions to come in, we didn't have questions, but we did have several people say thank you for your presentation. Oh, we did have one late question. Is it reasonable to assume that the city could be sued in the CCNR scenario if they approved a particular use? I think going back to this, the CCNR. So if there was a use that was outside, that was maybe banned in a CCNR, and the city or jurisdiction allowed something that was specifically against that to happen in the neighborhood right next door or within that area.
Yeah, here's where you're sort of in the catch-22, because I would say you'd probably be just as likely, maybe even more so, to be sued if you let a private covenants, conditions, and restrictions determine how you went around and how you ended up discharging your duties under your ordinances. And so, could you be sued if you ended up following your ordinances and approving a use that was in violation of the CCNRs? Yeah, I mean, I think you could be sued. The problem, though, is, I think if you ended up not approving something in violation of state law based on simply the fact that it was not allowed in the CCNRs, and you did not have grounds under the state laws that we've talked about here in this presentation to actually deny the conditional use. And again, there's that bullet point there, and there's that statute in LUDMA that gives you the express information about when you may deny it. And if you haven't met that and you simply deny it because it's not allowed in the CCNRs, I think you may have a harder time winning a court case that sues you for that. The defense would be, in this case, if someone did sue you, which they very well may, look, that's a private matter. We go through and we discharge our duties under our ordinances in accordance with applicable law. If you guys have an issue under private contractual law and you don't want them to be doing this particular conditional use, sue them for an injunction. Go ahead and sue them for damages under the CC NRS. That's your remedy. Your remedy is not to come to us as the land use authority and say, you have to sort of fudge state law and your own ordinances in order to get us what we want based on, a private contractual matter. So that's
great answer.
My view on it. So
yeah, great answer. I think that explains it very well.
Sued.
Yeah, and it's been our experience that you can get sued for a lot of things. Where they can prevail is it may be a different story. So, great. Thank you once again, Jim. I sure appreciate that. And we really appreciate the partnership with the Property Rights Ombudsman's Office in helping us out. Just to remind you, we will be doing these webinars quarterly throughout the year. And if you're not receiving notifications on that, please send me an email, and we'll get you on that distribution list. That's my email is jason@utahtrust.gov, and you can also always go onto our website, utahtrust.gov, click on training and events, and you can sign up right from that location and be a part of this and live training and other webinar training as well. Thanks once again, Jim. I appreciate everybody for attending today. We will we'll finish the recording and place that up on the webinar later and distribute those slides. Thanks, Jim.
You bet. Thank you, and thanks everyone for joining.